There was a judgment entered against you at some point in time. Based on that judgment, they filed a garnishment against your wages, right? You filed an objection to garnishment. So, for example, one of the most common ones I get is when somebody's bank account has been seized and the defendant files a motion objecting to that garnishment saying the only money in that bank account is for my Social Security check and they can't have that money. That's a legal objection to the garnishment. What you're telling me is the garnishment shouldn't have been issued because the default judgment should not have been issued. You need to argue the judgment. Motion date as to Mr. Martin, what's your pleasure?
I guess if I would like to have a trial date with the ability to file a motion if you just give me a deadline for that.
Okay. Has there been a jury demand filed?
No.
All right. So if I give you a bench trial date, maybe 90-ish days down the road, that'll give you time to decide if you want to file a motion and do so?
Yes, Judge, thank you.
Okay. And Mr. Martin, I'm going to try to answer your questions and interpret. I know we tend to speak our own language. Heather, can you give me a bench trial date around 90 days down the road?
We have December 17th, which is your regular general civil day. We can do maybe 10:30, or would you rather the afternoon?
That should work.
Okay. And that's it live or Zoom?
Live.
Okay.
Gentlemen, does that work? December 17th at 10:30 live?
It does.
It does for a plaintiff, Your Honor, at least until I check with a witness.
All right. Thank you. All right. So, Mr. Martin, when counsel refers to motions, he may decide to file a motion. Mr. Mueller, I'm assuming you're talking about a summary disposition motion?
Correct.
Thank you. All right. So he may decide that he thinks he's got a good argument that based on the facts in this case that are not in dispute, the law entitles his client to a judgment without a trial. So if he thinks he's got a valid argument, he's going to file a motion. He'll send that to the court. You'll get a copy of it. You'll have a chance to respond to that both in writing and orally. If I buy his argument and I grant that motion, then I will give a judgment in favor of the plaintiff and there will be no trial. If I don't buy his argument and I deny that motion, then we're going to go forward with that trial date. Do you understand that?
Yes, fully.
Okay. And counsel, what are we doing as to defendants 2 and 3?
I've already filed a default judgment on, let me just say which one, on magnumtools.com and I guess that's it.
I got defendant 2 and 3 listed both as magnumtools.com LLC. So I don't know if that's a typo on our docket printout.
I show only 2 defendants.
Okay, so that's just a screw up on our end. All right, so we've got a bench trial date scheduled December 17th, 2024. Anything else that you need from the court, gentlemen?
Nothing from plaintiff.
Mr. Martin?
Nothing from the defendant, Your Honor.
All right, good luck, gentlemen.
Thank you, Judge. Have a good day.
Thank you.
You as well.
Judge, next we have Citibank versus Bauer.
All right, give me just a minute.
Oh, yep, sorry.
This is the spirit of your father needs.
Okay, all right. All right, I'm sorry, give me the file name again.
Citibank versus Bauer, the last one at 9:30.
Oh, I got it, thank you. Appearances on that file, please.
Navrat Francis on behalf of plaintiff's attorney Becker.
Good morning, Your Honor. Leslie Honig on behalf of the defendant.
Good morning, ladies. You've had a chance to talk?
We did. We're just asking for some discovery, 60 days, Judge.
Okay, I think that was a November 12th date. Is that right, Heather?
That was, Judge.
All right, ladies, we just going to adjourn the pretrial?
Sure.
That's agreeable.
8:30.
8:30 work?
Yes.
And written discovery, correct?
Yes.
Okay, anything else we can do?
No, Your Honor. Thank you.
Okay, good luck, ladies.
Yeah, so are you on mute?
You're not, Mr. West.
You got anything else, Heather?
Yes, we have, Mr. West, keep yourself muted. Don't touch it. JP Morgan versus Pupava.
Yep, I got it.
Thank you.
Appearances for JP Morgan?
Yes, Your Honor. Christopher Royce on behalf of the plaintiff.
Thank you. And did defendant show up? Melanie Pupava?
Well, Your Honor, we do have a Melanie Peacock who was served with the suit. I apologize. And
That's okay.
so I think we might have the wrong person. So if we can adjourn it 30 days, we'll probably get this one dismissed against the individual received and refile against the true person.
Okay.
That's
Ma'am,
October. I'm sorry.
ma'am, do you understand that?
Yes, it's not me, so you guys can do whatever you want.
Okay. Okay. All right, Heather, what was the date? October?
October 15th at 9:15.
All right. All right. Thank you.
And
counsel.
do I need to show up for that or no?
I'm going to get you. I'll be in touch. Yeah, we'll have this thing dismissed before,
Okay.
but that's just a control date as we were talking about.
Okay.
So the court makes sure
Okay.
it continues to move along.
Thank you so much.
Thank you. Take
All
care.
right.
Have a
Thank you,
fabulous
folks.
day. Bye-bye. Bye-bye.
Heather, what else?
First Portfolio versus Anthony Wafer.
Good morning, Your Honor. Alexander Sarhan, P77252 on behalf of plaintiff.
Thank you. Mr. Wafer, can you hear us all right?
Yes, I can hear you.
Okay. All right. And gentlemen, you've had a chance to talk?
We have, Your Honor.
All right. Have you resolved anything, counsel?
We have not, we can, happy to let the defendant go with his objection. I can let you know, sort of what's going on our end, and I'll just defer to the court to make its decision.
Okay. Thank you. Mr. Wafer, I don't have your paperwork in front of me, so tell me what your objections are. What are the reasons for your objection?
So first, I didn't know nothing about this. So the first time I know something about this is where my check was like halfway gone. So I called my employer and they said that you have a garnishment out of the 34th District Court. So then I called the court and then I came into the court the next morning to file the objection to the garnishment.
Right.
And because I don't even know who First Portfolio Ventures is. And then they said the original company was CM something I never had a contract with. So that was first. And then the second thing that I had a problem with is they said that they personally served me at an address I never lived at. The documentation here at the court that gave me said the person was 5'10", 170 pounds, 45 years of age. I'm 6'5", 215 pounds. I don't think I look 45. So that's why I didn't get none of this, because they said they served somebody that lived at that
Right.
address.
Right.
And then the other problem I have is they have a address at 7640 Marlowe Road, Belleville, Michigan. I don't know who supplied that address or how they got it, but the only way to get that address is they pulled my credit report without my consent. So they broke the law doing that, because the only way to get that address was to pull my credit report, because the person that lived at that address added me on as an authorized user to their credit card. So I never used that address in my life. So they probably pulled my credit report and seen, oh, here's another address. I can see if he lives here. And they went there and said that they served me. They said they served me there. But the person that lives there is him and his wife. And he's 6'4", 350 pounds. And he's only 30. He's 28. So, and they're Caucasian. So I don't know what black male they served at the address. So that was the two things I had a problem with. I could never object. I could never object to the first time because I never received anything.
Okay.
And then once they said they served me, they just entered in the court, and then the court accepted it because I didn't know nothing about it.
Right. All right. So everything you just told me, are reasons to object to the default judgment that was entered against you. Would you agree?
Yes.
Okay. What's up today is an objection to garnishments.
Mhm.
All right. There are very limited legal objections to object to a garnishment, none of which I've heard about. So what you need to do is you need to file a motion to set aside the default judgment.
Okay, that's what they said that. And you said that was called what again?
A motion to set aside the default judgment. There was a judgment entered against you at some point in time.
Mm-hmm.
Based on that judgment, they filed a garnishment against your wages, right?
Yes.
Okay. You filed an objection to garnishment. So for example, one of the most common ones I get is when somebody's bank account has been seized and the defendant files a motion objecting to that garnishment saying the only money in that bank account is for my social security check and they can't have that money. That's a legal objection to the garnishment. What you're telling me is the garnishment shouldn't have been issued because the default judgment should not have been issued. You need to argue the judgment.
Okay.
All right. So counsel, I'm assuming you have not been able to share any information with Mr. Wafer, convincing him that this underlying account was his.
That's correct.
Okay. All right. So Mr. Wafer, what I'm going to do is I'm going to deny your objections to the garnishment, suggest you file a motion to set aside the default judgment.
Mhm.
Then we can get into these issues because counsel didn't know he was coming in to argue that motion today. Right? You follow me?
Mm-hmm.
Okay. So based on what you're telling me, it may be set aside. I mean, all the stuff that you just gave me, it might be set aside at that point.
Okay.
Anything else?
No. So
All
I just
right.
walk into the court and do it. Can I do that over online or?
Well, it's possible to do it online. Whether or not you can, I don't know.
Okay.
So there's a form that needs to be filled out. You can access that form and email it to the court or send it through on my file. That's fine. Or you can come into court personally.
Okay.
All right. Any questions, sir?
Nope.
Counsel, anything to add?
Nothing for plaintiff, Your Honor. Thank you.
All right. Have a good day, gentlemen.
Everything's.
Heather, what else you got?
West versus Gem Seal.
All right, gentlemen, your appearances, please.
Good morning, Your Honor. Michael Hinch on behalf of the defendants.
Daryl West, Roper.
Thank you. Mr. West, how are you feeling?
Terrible.
Well, at least you're not in the hospital. I can tell by your background you're at home.
I'm not in the hospital. I'm out just so we can deal with this.
All right. Well, good luck, sir. So I think what's up today is defendant's motion to dismiss. Is that correct?
That's correct, Your Honor. I know Mr. West had requested another adjournment. I don't know if the court would entertain that or not. Mr. West, I don't know if you'd like to discuss that with the court, but I just want to at least give Mr. West the opportunity.
We just have both spoken, and I think that an adjournment is in both parties' best interest to try and resolve the matter.
I'm not adverse to an adjournment if both parties agree. How far out would you like to go? You want to go out to my October date?
I think that would be fine, Your Honor, if it's fine with Mr. West.
Yeah, I think we made a presentation of settlement, and if he can resolve it for us, we'll work with that, and that's our position.
How about October 15th? Heather, what time you want to do that?
9:45.
Gentlemen, that work?
Works. What day is that?
That would be a Tuesday.
Yeah, Tuesdays available.
This is McAfee.
Yes, good morning, Judge. This is Cassandra McAfee. Unfortunately, I'm trying to start by video, but it's not allowing me to.
Okay.
But I am definitely here.
We can probably struggle through without it. Who's representing Calvary today?
Mr. Royce, who must be in another Zoom.
Sorry?
Are you on
Yeah, I can.
Calvary
I can
versus
speak.
McAfee? All right, are you ready?
Hello?
Yeah, are you ready on that, Calvary
Yes,
versus
yes, I am,
McAfee?
Your Honor.
Your appearance.
Yes, Christopher Royce on behalf of the plaintiffs.
Thank you. Ms. McAfee, today is the date and time set for a pretrial. That is an opportunity for me to get some information about this particular file and hopefully move it towards a resolution and get it on the calendar. Counsel, have you had a chance to speak to Ms. McAfee?
Yes, I have, Your Honor.
Where are we at?
Well, I think that she's going to submit an offer, and then, which of course, on Calvary case, I have to submit it to the client. But I think we spoke, and I think she's agreeable to a 60-day period of discovery.
All right, how about November 12th?
That sounds good.
Heather, what time?
8:30 is good.
Ms. McAfee, that work for you, November 12th, 8:30 in the morning?
Yes, it does, Judge. I really
All right.
appreciate it. Thank you.
You're welcome. All right, discovery is an exchange of information and it is meant to be a two-way street. So I'm assuming Mr. Royce is probably going to send you a list of questions that he wants answered. He might send you a list of documents that he might think you have in your possession that he wants to look at. You can do the same thing. If there's anything from Calvary that you think you need to put together your defense, you can ask Mr. Royce for those documents or that information. Understood?
Yes, I do.
All right. Any questions, ma'am?
No, I'm all set, Judge. I really appreciate the time this morning.
You're welcome. Counsel, anything else?
No, Your Honor.
All right. Have a good day.
Thank you. Thank you, Heather, for your help.
You're welcome. Have a good day. Next judge is LV Envy versus Jones.
I've got that one. Counsel for Jones or counsel for LVNV.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Good morning. Ms. Jones, can you hear us okay?
Yes, I can.
Thank you. Good morning. This
Good
is the date
morning.
and time set for a pretrial. That's an opportunity for me to get some information about the file and hopefully move it towards a resolution. Counsel, you ladies have talked?
Yes, we have, and Ms. Jones does not recall this debt, so plaintiff requests 90 days for discovery so that we can have an opportunity to send her documentation to hopefully refresh her memory.
All right, so we'll just adjourn the pretrial then, discovery until then?
Yes, please.
All right, so that date is December 17th.
Okay.
What time, Heather?
8:30 is good.
All right. And Ms. Jones, did you just hear my explanation about what discovery is, the exchange of information?
Yes, sir.
Any questions about that?
Yes, I need to know what type of information you're referring to, as far as this case is concerned.
Well, it could be any information you think that LVNV has in their possession that would help you prepare your defense.
Okay. All right.
All right.
Like I said, I don't even know who LVNV is, though.
Okay.
All right.
Well, that will probably be part of what counsel says she's going to send you.
Okay. All right.
She probably has some old account statements or something like that.
Okay.
All right.
All right.
Any other questions, ma'am?
Nope. That's it. Thank you, sir.
Counsel, anything else?
No, Your Honor.
Have a good day, ladies.
Thank you. You as well.
Thank you.
And that's it for right now, Judge. We're waiting for the other parties of the other two cases that are on.
Thank you. Okay, you're confusing me with Macomb funding.
Judge, that doesn't appear because the way that they scheduled this, Macomb funding is the plaintiff.
Oh, I got you. I got you. All right. All right. So according to my paperwork, we've got a defendant 3 is Serval. What about defendants 1 and 2, counsel?
Yes, Judge Kim Corbin on behalf of the plaintiff. You have entered a default judgment and actually an order of eviction was entered on August 9th. This case is a post-foreclosure case to get into the property and to terminate redemption rights. You entered that judgment. We haven't received any response from anybody. And the problem is there were a bunch of lien holders. So one of those lien holders is up for hearing today because we finally got service on them in Delaware on
Okay.
August 28th. So we're looking for a default judgment as to serve all underlying trust. That's
Gotcha.
SERV. So what I'd like to do is submit a default judgment, giving them 10 days, and it terminates their redemption rights. In addition to that, though, Judge, I need to bring to your attention the fact that I filed a motion to add as a defendant Deutsche Bank trustee for Novastar, and you entered an order on September 4th to add them, but I need a summons, and then I guess the next thing is to schedule a court date for that, and I'll get them served with the new summons, and
Okay.
and then we can hopefully wrap this case up.
Okay. So that would be defendant 4. Deutsche Bank. Okay. All right. Okay. So submit your default judgment on Serval.
Yeah, who should I contact about getting the summons issued, Judge? Because I submitted it with my motion. I guess I'll just call the civil clerk and ask her about getting that done.
Yeah. In the meantime, Malachi, can you check for that and see if it's in OnBase somewhere?
Yeah, I could check for that. I seen that it was issued, but I'll check to make sure.
All right. So we're looking for a summons so we can get Deutsche Bank added.
And a court date. Wonderful, Judge. Thank you. This case has been like a bar exam final. So I'm happy that you're right on board. So I'll get that judgment into you today.
It's a master class on property law, right?
Thanks, Judge.
Yeah. All right. Have a good day.
You too. Bye-bye.
Mr. Evans and Mr. Helminack, we're just waiting till 10:30 to call the defaults
Okay.
if the other parties don't appear.
Yeah.
Understood. Thank you.
Thank you.
Mr. Evans, what type of hearing do we have scheduled? You're muted.
Unmute
Still
yourself,
muted.
Mr. Evans. Unmute. Hit the audio button. It has a red line through it, down at the bottom. Yep, are you looking at your screen?
Yeah.
There you go.
Got
There
me.
you go. What type of hearing is scheduled for today, sir?
Judge, Miss Poirier was hopefully going to show up today and show me how she's going to pay me. I was
Okay,
hoping to get her
discovery hearing? Okay.
Yeah, I was supposed to get her social security number and figure out how she's
Okay.
going to pay me back.
All right. We'll give her a few more minutes, see if she shows up. Thank you.
All right. Thank you, sir.
Seeing Miss Poirier, looks like it's been 30 minutes. So what is your judgment amount? You're
Unmute
muted.
yourself.
There you go. $4,500, Your Honor.
All right. All right, if you submit a bench warrant in the amount of $1,000, I'll sign it. We'll see if that gets your attention.
Okay, sir. How do I do that now?
It's forms that have to be filed with the court.
Okay, I'll come up to the court, to the clerk office and fill out the forms. And I'm asking for what, sir?
I would bet they have the form available, a bench warrant.
Bench warrant. Okay, sir.
Good luck.
Thank you. Bench warrant.
All right, is it Helminack? How do you say it? You're muted.
My dad said if anyone asks, it's Smith. No, it's Halmaniac.
I like that. Say it again.
Halmaniac.
Halmaniac. Good morning, sir. So
Good morning.
this is pretty unusual when the attorney for the plaintiff doesn't show up. So I'm going to dismiss this action. I'm going to guess that they'll file a motion asking me to reinstate it. If they do, you'll get a notice and we'll have that discussion at another time. Understood?
Yes, sir.
Any questions?
Not at this time, no, sir.
All right. Enjoy your day.
I will. You as well, too. Thank you.
All right. Thank you, Mr. Smakowski. I am going to refer you to my probation department downstairs. They're going to schedule with you to come back for an interview and a sentencing date. Based on that interview, they're going to put together a report and a recommendation of sentence. You'll have a chance to go over that with Mr. Bowditch for your sentencing date. I will have read that report, then we'll talk about that report and anything else you want to talk about before I sentence. You understand all that? In the meantime, I'm going to put you on a personal bond. First two conditions are pretty obvious. One, stay out of trouble. Two, cooperate with the process so we can move you towards sentencing. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond?
Yeah.
Any questions? You're all set. Go on downstairs. Front counter, they'll call your name, give you those dates. Enrique, you're welcome. Enrique Cano Hernandez.
Thank you, Your Honor. Thank you, Your Honor. For the record, Jeff Bottom. Yeah. Sir, could you tell us the name?
Enrique Jose Cano Hernandez.
Good morning, sir.
Your Honor, today is date time set for arraignment in this matter with full briefing standing. We've also had a chance to pre-trial this case, Your Honor, which is 2022 and 2019 case. On both of these matters, Your Honor, we have an executed plea agreement subject to court approval. In both of these matters, Mr. Cano would be pleading guilty to an added count of no operating license on person, given the understanding the original charges would be dismissed.
Thank you. Sir, do you understand your rights and options? You understand the possible penalty?
Yes.
Understanding this, are you pleading guilty to two charges, 2 counts of no valid operator's license on person? And are you doing so freely and voluntarily today? On January 7, 2022, did you drive a vehicle in Van Buren Township? Was your license suspended, revoked, or denied at the time? November 4, 2019, did you drive a vehicle in Van Buren Township?
Yes.
Was your license suspended, revoked, or denied at the time? I'll accept your plea to both added charges, dismiss both the original charges. What's the status now?
Your Honor, he's working on, he has to settle an immigration issue, and then he'll get his CDL back. He has to get it on.
Okay.
Your Honor, the only thing that might come in, and I don't know, he was since 2022. Matter of fact, I think this year, he hasn't been incarcerated.
Since 22?
Yes, since 22. Matter of fact, I think it was this year.
This year, that's just.
And I don't know if the judge would, if his incarceration would matter the length. I think it was 11 days for this court, but he did 4 months. I think between here and Livingston.
Yeah.
Yeah.
How was he in jail on these files?
Here, it was, possession of stolen property with harm.
Okay, so you weren't in jail on these charges?
Out of this court, a felony.
Court, yeah.
Understood. All right. Okay. All right. And are you working now? Where at?
Like for myself, self-employed.
What do you do?
Construction, basically.
What kind?
Everything basically except driveways.
Okay. All right, we've got a speeding ticket from 2019, a registration plate charge from 2022, a no proof of insurance from 2022, $1,200 worth of tickets you've never done anything on. Why not?
Here,
Here.
I was told that's all I had. The driving suspended.
You were told by who?
The judge that I saw for because they put me on diversion.
Okay.
They said you have to take care of these 2 tickets, and that was these 2. I did not.
Okay, well, they might have been talking about misdemeanors.
Oh.
Yeah.
With a civil infraction, if you if you serve some default.
Oh.
If it's a misdemeanor, you get a warrant. If it's a civil infraction, they just assume your guilt.
Oh. Well, I have to take care of all of them now, no matter.
Are you in a position to do that?
Right this second, no, but I can do it in the next 2 weeks.
All right, so those tickets are $1,281. You can take care of that in 2 weeks?
Yes.
Okay, so by the 9th? All right, that takes care of that pile of money. Anything you want me to consider before I sentence you on today's files? All right, normally on these charges, I would assess fines and costs and 4 days on the court work program, but given the fact that we had you for a while on some other files with jail, I'm going to waive that. You're welcome. All right, unfortunately, because these files are so old, and we haven't seen you, you've racked up some late fees and penalties. So on each of these files, fines and costs is $650. I'm going to let you set up some kind of payment plan or payment arrangements downstairs today. So before you get out of here, have a paper plan on how we're going to get our money on those. All right, whether or not that's a due date, you're going to pay it all, or if you're going to do it over payments, however you do it.
Yeah, I'm gonna make payments on first.
Yeah, yep. But before you get out of here, I need that on paper.
Okay.
You're all set.
Thank you. Thank you, Your Honor.
You're welcome. Aaron, is it Franchuk? How do you say it?
Franchuk.
Counsel, your appearance.
Good morning, Your Honor. A piece of sound from Florida. On behalf of the defendant, Aaron Franchuk, you stand to my right. Please state your name for the record.
My name is Eric Stephen Franklin.
Good morning, gentlemen. Tell me about the plea.
Yes, Your Honor. For the purpose of arraignment, like waive the formal reading and stand mute.
Done.
I did have an opportunity to speak with the prosecutor for purposes. We reached an agreement in this matter, Your Honor.
Go ahead.
To dismiss the original 2 counts. It's going to be in section of civil infraction. My client would please be responsible for the double parking.
I see that, and he's agreed to pay fines and costs of $400.
Yes.
All right, I'll do it on the civil infraction, Heather. And can you pay the 400 today?
I can pay next week.
We do 14 days, Your Honor. If that's
Sure.
Thank you.
All right, both original charges are dismissed. Hold on, what do we got all here? Except for. All right, you've got something coming up for a review on January 5. Oh, offer sent to attorney on 12/9, must respond by 12/17. Are you handling some civil fractions for me?
Civil fraction.
Yeah, that one I just talked about was a speeding 21 over. And then we got another one. Failed to signal observe, review set for 12/18/25, still in pending status. Yeah, you might want to check those downstairs so we don't miss a deadline.
Absolutely.
All right, have a good day, gentlemen.
Thank you.
You as well.
Thank you.
What's this pile up here?
Old scratch.
Yaman El Ahmad?
Good morning, Judge.
Morning.
Half of Mr. El, say your name for the court.
John Lawson.
So
You just need a new date?
yes,
Okay,
the arraignment, you stand mute, really reading out the information.
all right. You working? Go ahead.
He is requesting a court appointed attorney to retrial.
Okay, all right. You're working? Where at?
Lowe's.
How long you been at Lowe's? Heather, can we do a pretrial 212?
Yes, Judge Martin. Is his last name ELHMAD?
Yep. What time,
Fine to me, or we get different?
No, it's signs you.
Okay.
who, or what time we doing that?
212 is gonna be 9:30.
And you said that's Judge Martin?
Correct.
All right. Sir, I'm gonna put you on a personal bond. First condition and second condition, both are kind of obvious. Stay out of trouble and show up for your court date. Third condition is do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Can you abide by those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond? Any questions? You're all set. Just wait a minute. We'll get you a paper notice. Haley, is it Matthew? Did I pronounce it right? Counsel?
Morning, Judge Dion Penelope, 82378 on behalf of Ms. Matthews. State your name, please. Adrian Hill. So, Your Honor, as to the name fans, and you way reading, I've had opportunity to discuss this matter with the prosecutor. There is an agreement to dismiss the original charge of operating while intoxicated, and Ms. Matthews would plead to operating while visibly impaired.
Thank you. Ms. Matthew, did you discuss with counsel your rights and options? You understand all those? You understand the possible penalty for the added charge? Understanding all of this, are you pleading guilty freely and voluntarily today? Counsel, if you would voir dire, I've got an incident date of October 9 this year.
Ms. Matthews, state your name for the court again one more time. And were you in the city of Van Buren Township on October 9th? Were you driving a motor vehicle? Prior to driving that motor vehicle, had you consumed alcohol? And do you believe that alcohol impaired your ability to satisfy?
I'm satisfied too. I'll dismiss the original charge. All right, Ms. Matthew, next step is I'm going to send you downstairs to the front counter. Probation is going to schedule for you to come back for an interview and a sentencing date. All right. I'll also put you on a personal bond in the meantime. Did you hear me do terms on the last one? First one is stay out of trouble. Second one is show up for your court date. Third one is, all right, raise your right hand. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions for counsel before I let you go downstairs? You're all set.
Thank you.
You're welcome. What was the name on that one I just handed you?
Yeah.
Feldkamp. Stay where you're at. We're just going to get you an adjourned notice date or adjourned date notice. So we'll take care of that. You're welcome. Front row, you're all together? All right, back row. All right. I'm gonna keep doing my base.
I did one thing that happened each day. Get it done.
Yes.
I didn't know.
No, that's,
Yeah.
say that one. It's not the end.
You said. So needless to say, I'm not getting it all. Depending about 70. If I'm changed. Where'd you go?
I thought you had a paper train. Thomas Makarowski. Good morning, Mr. Bowditch.
Good morning, record Jeff Valley, 45367, appearing on behalf of Tomkowski. Sir, could you tell the judge your name for the record, please? Well,
Good morning.
Your Honor, today's date time set for breaking in this matter. We waived former reasons. Also had a chance to pre-try this case. You have an executed plea agreement subject to court approval. In that agreement, Mr. Tomkowski, when you pleaded guilty to an addict, visibly impaired, understanding including the charge would be dismissed.
Thank you. Sir, did you discuss your rights and options with Mr. Bowditch today? You understand your, those options you're presented with?
Yes.
You understand the possible penalty for the charge?
Yes.
And how do you wish to plead?
Yes.
Are you pleading guilty freely and voluntarily today? Mr. Bowditch, would you voir dire?
Yes.
Morning, Mr. Kaplan.
When are you asking?
Offense date was October 11 this year.
Mr. Markowski, on October 11th of this year, driving, sir?
I was.
Were you driving in van here in town?
Yeah.
Had you been drinking?
Earlier, yes.
What had you been drinking?
Yes.
Do you believe because of consumption of that alcohol, your ability to drive a vehicle is impaired?
Yeah.
Did you take a breath test, sir?
I did.
Do you have any reason to doubt or challenge the validity of that test?
No.
Your Honor, I don't believe we know that. But, do you believe it was over the legal?
All right.
Yeah.
Defense is satisfied, Your Honor.
So am I. I'll dismiss the original charge.
Thank you.
This courtroom hearing begins with what seems like an ordinary wage garnishment dispute, but it quickly turns into a fascinating lesson about how the legal system works. At first glance, it appears that the defendant simply wants the court to stop money from being taken out of his paycheck. However, as the hearing unfolds, it becomes clear that the issue is much deeper than that. The defendant explains that he had absolutely no idea a lawsuit had ever been filed against him. According to him, the first time he learned anything about the case was when he noticed that a significant portion of his paycheck had suddenly disappeared because of a court-ordered garnishment. Naturally, he was shocked and immediately contacted his employer to find out what had happened. His employer informed him that a court had issued a wage garnishment. Wanting answers, he contacted the court and filed an objection. During the hearing, he passionately explains that he doesn't even recognize the company attempting to collect the debt. He says he never signed a contract with them and has no idea why they are claiming he owes money. But his biggest concern is the issue of service. He insists that the legal documents were delivered to an address where he never lived. Even more surprising, the physical description of the individual who supposedly accepted the documents doesn't match him at all. The paperwork describes someone much shorter, lighter, and older than he is. According to the defendant, the court records simply don't describe him. As the defendant continues speaking, he raises another serious concern. He believes the company obtained another address connected to him by improperly accessing his credit report. He explains that this address belonged to someone who had once added him as an authorized user on a credit card, but he himself had never lived there. He argues that the debt collector searched for additional addresses and attempted service there instead. From his perspective, everything about the lawsuit was handled incorrectly. The judge listens patiently without interrupting. Instead of immediately ruling in favor of either side, he carefully analyzes what the defendant is actually arguing. This is where the hearing becomes especially educational. The judge explains that although the defendant's complaints may be legitimate, they are being presented during the wrong type of hearing. Today's hearing is only about the wage garnishment itself, not about whether the original judgment was properly entered. The judge then provides a simple example that almost anyone can understand. He explains that a legal objection to a garnishment usually involves protected money, such as Social Security benefits that cannot legally be seized. Those are issues directly related to garnishment. What the defendant is describing, however, is something entirely different. He's arguing that the original default judgment should never have been entered because he was never properly notified of the lawsuit. At this point, the courtroom transforms into a real-life law class. Instead of dismissing the defendant's concerns, the judge carefully teaches him the proper legal procedure. He repeatedly explains that if someone believes a default judgment was entered without proper notice, the correct solution is to file a motion to set aside the default judgment. That motion allows the court to examine whether service was valid, whether proper notice was given, and whether the defendant deserves an opportunity to defend himself. One of the most impressive aspects of this hearing is the judge's patience. Many judges simply rule on the issue before them and move on. Instead, this judge takes several minutes to ensure the defendant fully understands the legal process. He avoids complicated legal terminology whenever possible and explains each step in language an ordinary person can understand. Perhaps the most encouraging moment of the hearing comes when the judge tells the defendant that, based on everything he has heard, the judgment might actually be set aside. Notice that the judge doesn't promise victory. He doesn't say the defendant is definitely right. Instead, He explains that the arguments deserve to be presented through the correct legal motion where both parties will have an opportunity to provide evidence. This demonstrates an important principle of fairness within the legal system. Courts are not only concerned with reaching the correct result, but also with following the correct procedures. Even someone with a potentially strong case can lose if the proper legal process isn't followed. Likewise, someone who appears to have already lost may still have legal options available if procedural mistakes occurred during the original lawsuit. The plaintiff's attorney also behaves professionally throughout the hearing. Rather than arguing aggressively, the attorney simply acknowledges that they were not prepared to litigate a motion to set aside the judgment because today's hearing concerned only the garnishment. This highlights another important aspect of civil litigation. Both parties deserve advance notice about what issues will be argued so they can prepare appropriate evidence and legal arguments. The judge ultimately denies the objection to the garnishment, but that should not be misunderstood as a victory for the plaintiff. In reality, the judge explains that the defendant is pursuing the wrong legal remedy. By directing him to file the proper motion, the judge is effectively preserving the defendant's opportunity to challenge the entire judgment in a future hearing. For viewers unfamiliar with civil procedure, this case demonstrates how lawsuits often involve several separate legal stages. First comes the lawsuit itself. Then, if the defendant doesn't respond, a default judgment may be entered. Only after that judgment exists can collection methods like wage garnishment begin. Challenging the garnishment does not automatically challenge the underlying judgment. Each stage has its own legal rules and procedures. Throughout the hearing, the judge remains respectful even when correcting the defendant's misunderstandings. He never ridicules him for not understanding legal terminology. Instead, he repeatedly checks that the defendant understands each explanation before moving forward. This creates an atmosphere where justice isn't simply about enforcing rules, but also about ensuring that ordinary citizens understand those rules. The defendant leaves the courtroom disappointed that the garnishment objection was denied, but he also leaves with something much more valuable, a clear understanding of his next legal step. Instead of feeling completely powerless, he now knows that he may still have an opportunity to challenge the original judgment if he files the correct motion and presents evidence supporting his claims. This hearing reminds us that many courtroom disputes are not about dramatic confrontations or emotional outbursts. Sometimes the most important courtroom moments involve careful legal explanations that help people understand their rights. Judges are not merely decision makers. They also play an important role in ensuring that the legal process remains fair, understandable, and accessible to everyone. In the end, this case serves as an excellent reminder that procedure matters just as much as the facts themselves. A person may have valid arguments, but those arguments must be presented in the proper legal forum and through the proper legal motion. By taking the time to explain this distinction, the judge demonstrates professionalism, patience, and a commitment to fairness. The biggest lesson from this courtroom moment is simple. Never ignore legal notices. But if you genuinely never received notice of a lawsuit, the law may still provide a path to challenge the judgment. Understanding the difference between attacking a garnishment and attacking the judgment behind it can completely change the outcome of a case. That's exactly what happened here, turning what looked like an ordinary debt collection hearing into one of the most educational courtroom moments you'll ever watch. Another fascinating aspect of this hearing is the professionalism displayed by everyone in the courtroom. Even though the defendant is clearly frustrated and confused, he remains respectful throughout the conversation. He never interrupts the judge, and the judge returns that respect by allowing him to fully explain his side of the story before making any decision. This kind of interaction reminds viewers that the courtroom is designed to be a place where people can present their arguments, even when those arguments ultimately need to be redirected into the proper legal process. One of the biggest misconceptions many people have about debt collection cases is believing that if they never borrowed money from a collection company, then the case must automatically be invalid. In reality, many debts are bought and sold between financial institutions and debt collection companies. That means the company appearing in court may not be the original lender. This often causes confusion because defendants see a company name they've never heard before and assume it must be fraud. The judge doesn't immediately address ownership of the debt because that's not today's issue. Instead, he focuses on the legal procedure that brought the parties into court. Notice how carefully the judge separates facts from procedure. Courts frequently operate in this way. Before deciding whether someone owes money, the court must first determine whether the legal process itself was followed correctly. If proper notice wasn't given, then the defendant may deserve another opportunity to defend the case from the beginning. That's why the judge repeatedly brings the conversation back to the default judgment instead of allowing the hearing to become a debate over the debt itself. The defendant also raises concerns about identity. He points out that the individual described in the service documents doesn't resemble him in age, height, or weight. If those claims are accurate, they could become significant evidence during a future hearing. However, the judge wisely avoids making factual findings without evidence. Instead, he simply acknowledges that these are exactly the types of issues that belong in a motion to set aside the judgment. This is an important lesson for anyone watching. Judges rarely decide complicated factual disputes during hearings that were scheduled for entirely different purposes. Every hearing has limits. Today's hearing concerns wage garnishment, not whether service was valid months or years earlier. The judge respects those limits while still helping the defendant understand how to pursue the correct legal remedy. Another interesting moment occurs when the plaintiff's attorney admits they weren't prepared to argue the service issue because they didn't know the defendant would raise those arguments today. Some viewers might think that's unfair, but it's actually an essential part of due process. Both sides deserve notice about what issues will be discussed so they can gather evidence and prepare legal arguments. Courts generally avoid surprising either party with entirely new legal disputes during unrelated hearings. The judge's explanation about garnishment is especially valuable because it teaches viewers the difference between enforcing a judgment and challenging a judgment. Those are two completely separate legal processes. Once a court enters a valid judgment, the winning party has several methods available to collect the money. Wage garnishment is only one of those methods. Others may include bank account garnishments, property liens, or other collection procedures permitted by law. However, if the judgment itself is later overturned, many of those collection efforts may also be affected. Throughout the hearing, the judge uses simple language instead of complicated legal terminology. Rather than overwhelming the defendant with procedural rules, he gives practical instructions. He explains exactly which motion needs to be filed, where the form can be obtained, and even mentions that it may be submitted electronically or delivered in person. These small details demonstrate that the judge wants the defendant to have a genuine opportunity to present his case correctly. This hearing also reminds viewers how expensive legal mistakes can become. A person who ignores a lawsuit or never receives notice of one can eventually face wage garnishment, damaged credit, additional court costs, attorney fees, and years of financial consequences. Many people mistakenly believe the first notice they'll receive is when money starts disappearing from their paycheck. Unfortunately, by that point, a judgment may already exist, making the legal process much more complicated. Another point worth discussing is the importance of keeping your address updated with creditors, employers, government agencies, and other organizations. Even when someone honestly believes they never received legal papers, incorrect addresses can create enormous legal problems. Courts generally rely on documented service attempts, and undoing a judgment later often requires convincing evidence that proper notice never occurred. From a broader perspective, this hearing highlights why civil procedure exists in the first place. Some people criticize procedural rules as unnecessary technicalities, but those rules are actually designed to protect everyone involved. Plaintiffs deserve a reliable system for collecting legitimate debts. Defendants deserve notice and an opportunity to defend themselves. Judges must balance both interests while following established legal standards. The hearing also demonstrates excellent judicial temperament. The judge never appears rushed despite managing multiple cases during the session. He listens carefully, asks follow-up questions, confirms his understanding, and explains his reasoning before making any ruling. This transparency helps everyone understand that decisions are based on law rather than personal opinion. As the court session continues with additional cases, viewers notice a consistent pattern in the judge's approach. Whether dealing with debt collection matters, scheduling disputes, discovery issues, plea agreements, or sentencing hearings, the judge remains patient, respectful, and focused on procedure. Every person receives an opportunity to speak. Every attorney is allowed to explain their position, and every ruling is accompanied by a clear explanation. That consistency builds confidence in the fairness of the judicial process. One of the most valuable lessons from this video is that understanding the legal process can be just as important as understanding the facts of your case. Many people believe that simply being right guarantees success in court. In reality, courts require both strong facts and proper procedure. Missing deadlines, filing the wrong motion, or appearing at the wrong type of hearing can significantly delay justice, even when someone's underlying argument has merit. By the end of the hearing, the defendant doesn't walk away with an immediate victory, but he does leave with something extremely important, a roadmap. Instead of remaining confused about why his objection failed, he now understands the exact legal steps necessary to challenge the judgment itself. That knowledge could completely change the future of his case. Ultimately, this courtroom moment is less about debt collection and more about access to justice. It demonstrates that judges are not simply there to decide winners and losers. They are also responsible for ensuring that litigants understand the legal process, especially individuals representing themselves without attorneys. The judge's willingness to explain the law patiently transforms what could have been an ordinary procedural hearing into an educational experience for everyone watching. For anyone following real courtroom proceedings, this case offers an excellent reminder that the legal system is often far more nuanced than it appears. Initial appearances can be misleading. Procedural rules matter enormously, and sometimes the most important courtroom victories begin not with a dramatic ruling, but with a judge taking a few extra minutes to explain the correct path forward. Those few minutes of explanation may ultimately prove far more valuable than any immediate decision the court could have made. This courtroom hearing begins with what seems like an ordinary wage garnishment dispute, but it quickly turns into a fascinating lesson about how the legal system works. At first glance, it appears that the defendant simply wants the court to stop money from being taken out of his paycheck. However, as the hearing unfolds, it becomes clear that the issue is much deeper than that. The defendant explains that he had absolutely no idea a lawsuit had ever been filed against him. According to him, the first time he learned anything about the case was when he noticed that a significant portion of his paycheck had suddenly disappeared because of a court-ordered garnishment. Naturally, he was shocked and immediately contacted his employer to find out what had happened. His employer informed him that a court had issued a wage garnishment. Wanting answers, he contacted the court and filed an objection. During the hearing, he passionately explains that he doesn't even recognize the company attempting to collect the debt. He says he never signed a contract with them and has no idea why they are claiming he owes money. But his biggest concern is the issue of service. He insists that the legal documents were delivered to an address where he never lived. Even more surprising, the physical description of the individual who supposedly accepted the documents doesn't match him at all. The paperwork describes someone much shorter, lighter, and older than he is. According to the defendant, the court records simply don't describe him. As the defendant continues speaking, he raises another serious concern. He believes the company obtained another address connected to him by improperly accessing his credit report. He explains that this address belonged to someone who had once added him as an authorized user on a credit card, but he himself had never lived there. He argues that the debt collector searched for additional addresses and attempted service there instead. From his perspective, everything about the lawsuit was handled incorrectly. The judge listens patiently without interrupting. Instead of immediately ruling in favor of either side, he carefully analyzes what the defendant is actually arguing. This is where the hearing becomes especially educational. The judge explains that although the defendant's complaints may be legitimate, they are being presented during the wrong type of hearing. Today's hearing is only about the wage garnishment itself, not about whether the original judgment was properly entered. The judge then provides a simple example that almost anyone can understand. He explains that a legal objection to a garnishment usually involves protected money, such as Social Security benefits that cannot legally be seized. Those are issues directly related to garnishment. What the defendant is describing, however, is something entirely different. He's arguing that the original default judgment should never have been entered because he was never properly notified of the lawsuit. At this point, the courtroom transforms into a real-life law class. Instead of dismissing the defendant's concerns, the judge carefully teaches him the proper legal procedure. He repeatedly explains that if someone believes a default judgment was entered without proper notice, the correct solution is to file a motion to set aside the default judgment. That motion allows the court to examine whether service was valid, whether proper notice was given, and whether the defendant deserves an opportunity to defend himself.